On Monday, March 3rd, I was standing beside my son's ICU bed when my sister leaned close and whispered that it was time to discuss the inheritance. My 8-year-old son, Eli, was fighting for his life at UPMC Children's Hospital in Pittsburgh. A clear ventilator tube curved past his mouth. Monitors traced thin green lines across a dark screen, each beep steady but fragile. The smell of antiseptic hung in the air, sharp and metallic. I had been there since before dawn, counting each breath like it was a favor the world was granting me. Lauren chose that moment to talk about money. She didn't say it loudly. She didn't say it cruelly. She said it the way someone suggests ordering dessert. "We need to be practical," she murmured, glancing at Eli as if he were already part of the past. Mom would have wanted us to settle things. The will, there were some changes. For a second, I thought I had misheard her. My mother, Margaret Price, had passed away 6 months earlier, after a long illness. We had buried her on a cold September morning in Allegheny County. And since then, I had been trying to keep my life from splitting apart, managing the family, VAC business books, helping Eli through asthma complications that had now spiraled into pneumonia, and grieving a woman who had held our family together by sheer force of will. And now, my sister was telling me that our mother's will had been changed. Eli shifted slightly under the thin hospital blanket. The plastic ICU wristband around his arm looked too large for him. I reached down and touched his fingers, warm but limp. "Not now," I said quietly. Lauren straightened. She was 34 older than me by 3 years, and she had always carried herself like she was entitled to the front seat. Her coat was still on, untouched by the antiseptic smell that had soaked into my clothes. "It has to be now, Hannah," she insisted softly. "There's a clause." The attorney explained it. "With everything going on, we need clarity. A clause, an attorney." My pulse began to pound in my ears louder than the machines. I had helped Mom draft her will 5 years ago with a small firm in downtown Pittsburgh. I had driven her to the appointment. I had read every page. There had been no mystery, no hidden language. I had been named co-executor with Lauren, equal partners, equal daughters. "What changes?" I asked. Lauren's eyes flickered just for a second. "You'll see the updated version soon. I'm meeting with the new lawyer this week." The new lawyer. I felt something inside me go very still. Eli's chest rose and fell with mechanical precision. Outside, the glass doors of the ICU nurses moved briskly between rooms. Life and death were unfolding on every side, and my sister was talking about paperwork. In that moment, the fear I had been carrying all day shifted into something colder. Not anger, not yet. Just a sharp awareness that something had happened without me. Lauren reached out and squeezed my arm, as if we were united in purpose. "We should be prepared," she said. Mom made decisions toward the end, prepared for what I watched, the ventilator, push air into my son's lungs, and realized I was the only one in that room thinking about him. And I understood, with a clarity that made my hands tremble, that whatever changes had been made to our mother's will had not been made with me in mind. The machines kept beeping. Lauren's phone buzzed. She glanced at it, then back at me. "We'll talk soon," she said, already stepping away. I stood there beside Eli's bed, staring at the small plastic bracelet around his wrist, and felt the first crack in something I had always believed about family. If there was a new will, I hadn't seen it. And that was the beginning of everything. Lauren left before noon on Monday, the same way she had arrived, careful, composed, untouched by the smell of the ICU. I stayed beside Eli's bed and tried to steady my thoughts, but her words kept circling back. There were some changes. A new lawyer, a clause. My mother had died 6 months earlier, in September, after a slow decline that had worn all of us down. Margaret Price had been practical to the end. Even in hospice, she had insisted on reviewing paperwork from the small HVAC company she and my father had built before he passed. Price Mechanical had serviced half of Allegheny County for 30 years, furnaces in winter, air conditioning in summer, the kind of steady work that paid mortgages and college tuition. After Dad died, I had stepped in quietly. I was 26, then, fresh out of graduate school, working in financial compliance for a regional healthcare network. Numbers made sense to me. Deadlines made sense. I took over the books for the business in the evenings, reconciled accounts, cleaned up vendor contracts. Mom used to joke that I was her safety net. Lauren was 3 years older than I was, but she had never been drawn to spreadsheets. She had a gift for talking to people, for persuading them. Mom called her the people person. Over time, that translated into something else. Lauren needed help with rent. Lauren needed help consolidating credit cards. Lauren needed seed money for a boutique marketing project that never quite materialized. I paid attention to patterns. I always had. When Mom first updated her will 5 years ago, I drove her downtown to meet with a small firm near Market Square. I sat beside her in the conference room. The attorney walked us through each page. Equal shares between her 2 daughters, co-executors, the business to remain intact unless both of us agreed otherwise. It had been clear, clean, and deliberate. Mom believed in fairness. In her final year, though, things became harder to track. She was in and out of the hospital with congestive heart failure. There were weeks when Lauren handled doctor visits because I was traveling for work. I didn't question it. I was grateful someone was sitting beside Mom when I couldn't. Now, standing in the ICU on that Monday afternoon, I wondered what had happened in those rooms when I wasn't there. The thought felt disloyal. Eli stirred under sedation, and I adjusted the thin blanket around him. His plastic hospital bracelet, white, impersonal, pressed into his small wrist. I focused on that instead, on the rise and fall of his chest, on the numbers glowing above his head. Lauren had said we needed clarity, but clarity for whom? My phone buzzed with a text from one of the office managers at Price Mechanical asking about a supplier invoice. Even here in the ICU, the business ran through me. I answered the question out of habit. I had always been the one who answered. That was the pattern. Lauren talked about potential. I handled consequences. As evening settled over Pittsburgh and the lights of the city reflected faintly against the ICU windows, I replayed the memory of her tone. Not grief, not confusion, strategy. She hadn't looked surprised that there was a new lawyer. She had looked prepared. And for the first time since Mom died, I felt the faint, unsettling sense that decisions might have been made without me. Not because I was incapable, but because I was dependable. I was the one who would keep things steady. Even when my son was fighting for air, I reached down and wrapped my hand around Eli's. If there were changes to my mother's will, I would see them. But not like this. Not whispered over the sound of a ventilator, and not without understanding exactly how they had happened. By Tuesday morning, March 4th, Eli was still on the ventilator, but his oxygen numbers had stabilized enough that the ICU nurse told me I could step out for a few minutes. It was just after 9. A gray Pittsburgh sky pressed against the hospital windows. I walked down the corridor with my phone in my hand, feeling as if I were doing something slightly disloyal, simply by shifting my attention away from my son. Lauren's words had settled into something heavier overnight. There's a new lawyer. There were changes. I didn't want to believe there was anything hidden. I also didn't want to be naive. I called James Barlow first. He had drafted my mother's will 5 years earlier in that small conference room near Market Square. I still had his number saved under Mom's attorney. His receptionist answered. I explained who I was, that my mother, Margaret Price, had passed in September, and that I needed confirmation of the most recent version of her will on file. There was a pause, papers rustling. Ms. Price, she said gently, Mr. Barlow is no longer handling your mother's estate. The file was transferred late last summer at your sister's request. Transferred, to whom I asked. She gave me the name of a firm I didn't recognize. Avery & Cole, located in a newer office building downtown. She added that the transfer authorization had been signed by my mother and witnessed in August. August. That had been the month Eli had his first hospital admission for complications from his asthma. I had been commuting between work and Children's Hospital, trying to keep everything afloat. Was I notified? I asked. I don't see any record of additional family notification, she replied carefully. You would need to contact the new firm for details. I thanked her and ended the call. My reflection stared back at me from the dark hospital window. Pale, exhausted, older than 31. Lauren had handled the transfer. I told myself that didn't automatically mean wrongdoing. People switch attorneys. Files move. Life is administrative. Still, something about the timing tightened in my chest. I called Avery & Cole next. A young-sounding receptionist answered with practiced brightness. I gave my name. There was another pause, longer this time. Yes, Ms. Price, she said. We're aware of your situation. Mr. Thomas Avery has been assisting your sister regarding certain estate updates. Assisting your sister. My sister and I are co-executors, I said evenly. At least we were under the last signed document I saw. Mr. Avery will be happy to schedule a family meeting, she replied. He did want to advise you not to interfere with ongoing administrative matters until that meeting occurs. Not to interfere. The phrase hung in the air between us. I'm not interfering, I said. I'm asking for a copy of my mother's current will. We'll have someone reach out, she said quickly. Probably later this week. Later this week. Behind me, a monitor alarm sounded briefly in another room. I felt the instinctive pull to turn back toward Eli. Before hanging up, I asked one more question. Was there an executor change filed? There was a silence, long enough for me to hear faint keyboard clicks. I'm not authorized to discuss specific amendments over the phone, she said at last. But all documentation was properly notarized. Properly notarized. That wasn't an answer. I ended the call and stood in the hallway for a moment longer than necessary. Nurses moved past me. A family down the corridor was crying quietly behind a curtain. Lauren had not sounded confused yesterday. She had sounded prepared. The file had been transferred in August, while my son was in and out of the hospital, while I was managing payroll and vendor contracts and trying to keep Price Mechanical stable. I went back into Eli's room and took my seat beside his bed. The plastic bracelet on his wrist caught the light. I told myself I was not drawing conclusions, but I now had something solid. A file transfer, a new attorney, and a warning not to interfere. Whatever had been changed, it had been set in motion before my mother died, and I had not been told. That was no longer a feeling. It was a fact. Wednesday, March 5th, began with the steady hiss of oxygen and the quiet rhythm of machines. Eli was still sedated, his small chest rising and falling with mechanical precision. The doctors were cautiously optimistic, but no one used words like certain. In the ICU, nothing was certain. At 10 that morning, while Eli's respiratory therapist adjusted a setting on the ventilator, my phone vibrated in my coat pocket. I stepped into the hallway before answering. It was Mark Delaney, the accountant, who had handled Price Mechanical's tax filings for over a decade. He had known my parents since I was in high school. His voice carried that careful tone people use when they sense something complicated. "Hannah," he said, "I need to confirm something with you regarding an ownership authorization request." My stomach tightened. What kind of request, I asked. "There was an inquiry submitted yesterday," he replied. It referenced a clause tied to beneficiary incapacity and temporary operational control. It included language suggesting that you might be unable to fulfill executive responsibilities due to personal circumstances. The words felt clinical, polite, devastating. "I'm not incapacitated," I said evenly. "I didn't assume you were," Mark answered quickly. But the language cited a codicil. It appears to be an amendment to your mother's will dated late August. Late August. The same month the file had been transferred. The same month Eli had been hospitalized the first time. I leaned against the cool hospital wall and closed my eyes. "What does the clause actually allow?" I asked. "It's narrowly written," he said. "In the event that one executor is deemed medically or emotionally compromised, the other may assume temporary operational authority over the business assets. However, it requires formal acknowledgement and supporting documentation." Supporting documentation. "Has any been submitted?" I asked. "Not yet," he said. "But the inquiry suggests someone is preparing to act." Someone. He didn't say Lauren's name. He didn't need to. I thanked him and ended the call. For a long moment, I stayed where I was, listening to the muted sounds of the ICU behind me. Emotionally compromised. The phrase lingered. My son was on a ventilator. I hadn't slept more than a few hours in days. I had answered supplier emails from a plastic chair beside his bed. And somewhere downtown, paperwork was being positioned to question my stability. I went back into Eli's room and sat down carefully. His hospital bracelet caught the overhead light again, that stark white band against fragile skin. My phone buzzed once more. This time, it was an email from Avery and Cole. The subject line read, "Notice of interest." My hands were steady as I opened it. The message was brief and formal. It referenced anticipated administrative adjustments to estate and business oversight structures. It suggested that given current circumstances, it would be prudent to convene a family discussion before any irreversible decisions were made. Irreversible decisions. There it was. Not an accusation, not yet, but a framework, a narrative being drafted in which I was the unstable variable. I read the email twice, then saved it. Outside, a nurse laughed softly at something another nurse had said. Life moved forward in small, ordinary sounds. Inside me, something shifted again. Not into anger, not yet, into awareness. The clause existed. The codicil had been notarized in August. An inquiry had already been made. No one had confronted me directly. No one had accused me of incompetence. But the structure was being built, and I was standing inside it, holding my son's hand, while someone else prepared to argue that I was too distracted to protect what my mother had left behind. For the first time, The inheritance did not feel abstract. It felt like leverage, and I could feel the pressure tightening. Thursday, March 6th, began with a call from the ICU physician just before sunrise. Eli had shown slight improvement overnight, not enough to celebrate, enough to keep hoping. Hope I was learning could exist alongside pressure. By 8:30 that morning, after the nurses completed rounds, I stepped into the hospital's small family consultation room and opened my laptop. I had not slept more than a few hours in 3 days, but my mind felt sharper than it had in weeks. I searched for an estate litigation attorney in Allegheny County with experience in contested wills and fiduciary disputes. One name kept appearing: Rebecca Sloan, former prosecutor. 2 decades of probate experience. Clear, direct reputation. I called her office. To my surprise, she answered the intake call herself. I explained my mother's death, the original will, the file transfer in August, the codicil referencing incapacity, the inquiry to the accountant, and the email warning me not to interfere. She did not interrupt. When I finished, there was a measured silence on the other end of the line. "Ms. Price," she said calmly, "do you have copies of the original will and any correspondence from the new firm?" "I have the original from 5 years ago," I replied, "and I have their email from yesterday." "Good," she said. "Send everything to my office. Immediately. If someone is positioning a temporary incapacity argument, timing matters. Timing. I'm not incapacitated," I said again, more firmly than before. "I understand," she replied, "but perception can be manufactured, especially when medical crisis is involved." Manufactured. The word settled heavily. Within an hour, I had scanned every document I possessed. Mom's original will, the business operating agreement, email exchanges with the accountant, the notice of interest from Avery and Cole. I forwarded them to Rebecca Sloan's secure address. By mid-afternoon, she called back. "There is indeed a codicil, dated August 22nd, she said. "It narrows executor authority under certain emotional or medical impairments. The language is subtle, but strategic." Strategic. Was I removed? I asked. "No," she said, "but the amendment allows your co-executor to petition for temporary sole authority if she can demonstrate that you are unable to perform your duties responsibly." "And who determines that?" "A court, ultimately," Rebecca said. "But before that, narrative matters. Documentation matters. Narrative." My son lay on a ventilator 20 yards away, and somewhere downtown, a narrative was forming about my instability. "There's more," Rebecca continued. "The codicil also references expedited review of business liquidity in cases of operational disruption. Operational disruption. If Lauren succeeded in framing me as compromised, she could control price mechanical, control payroll, contracts, cash flow. "This is moving faster than it should," Rebecca said, "which tells me someone is motivated." Motivated. I looked down at Eli's hospital bracelet resting against his pale skin. The beeping of the monitor filled the silence between us. "For now," Rebecca continued, "I recommend we prepare a formal response. We will request a complete accounting of all estate communications since August, and we will place the other firm on notice that you dispute any suggestion of incapacity. Place them on notice." It wasn't dramatic, it wasn't loud, but it was a line. I thanked her and ended the call. For months after Mom died, I had tried to keep peace. I had assumed good intentions. I had absorbed responsibility without complaint. But this was different. This was not about grief. This was about positioning. I walked back into Eli's room and sat beside him. I wrapped my hand around his small fingers and felt the warmth there. I was not going to argue in whispers in hospital corridors. If my sister wanted to turn my son's medical crisis into leverage, she would have to do it in the open. And for the first time since Lauren leaned toward me and said the word inheritance, I made a decision that felt irreversible. I would not remain silent. Friday, March 7th, began with a different kind of stillness. Eli was still in the ICU, but the ventilator settings had been lowered overnight. His oxygen saturation held steady in the mid-90s. The nurse told me it was a cautious step forward. I held on to that word, forward. At 9:15 that morning, Rebecca Sloan called to confirm she had drafted the formal notice. It was addressed to Avery and Cole, with copies to the estate file and the business accountant. The language was measured direct and unmistakable. My client disputes any assertion of incapacity. My client requests full accounting of all estate-related communications and amendments dated August 1st through present. No transfer of operational authority is authorized without court review. Rebecca read the summary aloud. It sounded clinical, controlled. Once this is sent, she said, the dynamic changes. They can no longer move quietly. Send it, I replied. By 10 o'clock, it was transmitted electronically and by certified mail. That was the moment the silence ended. Lauren arrived at the hospital just after noon. She wasn't breathless or frantic. She was composed, carrying a leather portfolio instead of flowers. Her hair was pulled back tightly, as if she were walking into a meeting instead of an ICU. "We need to talk," she said, glancing through the glass at Eli. "I'm not leaving him," I replied. "This won't take long." We stepped into the small consultation room down the hall, the same one where I had first called Rebecca. Lauren set her portfolio on the table and opened it carefully. "You hired an attorney," she said. It wasn't a question. "Yes." Her jaw tightened. "You're escalating this," she continued. "That's unnecessary. The codicil is precautionary. It protects the business if something happens. Something like what I asked quietly. Like you being overwhelmed," she said. "Hannah, your son is on a ventilator. You haven't slept. This isn't about attacking you. It's about stability. Stability. Stability for whom I asked. For everyone," she replied. "The company can't stall because you're distracted. Vendors need payment. Employees need reassurance." I held her gaze. "I answered vendor emails from the ICU," I said. "I approved payroll from that chair." "That's exactly my point," she snapped softly. "You shouldn't have to." There it was, the pivot, framed as concern. "You tried to initiate control," I said. "Without telling me." "I initiated nothing," she replied quickly. "I asked questions. The attorney suggested options. You're reading too much into it." But she hadn't denied the inquiry to Mark. She hadn't denied the codicil. "I won't sign anything," I said. "No one is asking you to sign," she insisted. "That's not what your lawyer implied." Her expression shifted subtle defensive. "You're making this adversarial," she said. "Mom trusted me too." "I know she did," I answered. "She trusted both of us." For a moment, neither of us spoke. Outside the door, a nurse wheeled a cart past, the metal rattling softly. Lauren closed her portfolio. "If you continue down this path," she said carefully, "it will go to court." "Then it goes to court," I replied. Her eyes hardened. "You're willing to fracture the family over paperwork." I thought of Eli's hospital bracelet, of the ventilator tubing, of the word incapacitated written into a document in August. "It stopped being paperwork when you questioned my capacity," I said. Lauren stood smoothing her coat. "I'm trying to protect what Mom built," she said. "So am I." She hesitated at the doorway. "This isn't over," she added. "No," I said. "It isn't." When she left, I remained in the consultation room for a few seconds longer than necessary. My hands were steady. The notice had been sent. The line had been drawn. Not loudly, not cruelly, but in writing. And for the first time since this began, the pressure no longer felt one-sided. By Monday, March 10th, Eli had been moved off the ventilator, but remained in the ICU. He was breathing on his own, fragile, but fighting. I took that as permission to leave the hospital for 2 hours. The meeting was scheduled for 11 a.m. at Avery and Cole's office downtown. Rebecca Sloan met me in the lobby. She was composed in a navy suit, carrying a slim leather folder. I carried something heavier, a 3-inch binder with copies of my mother's original will. The codicil, dated August 22nd, Mark Delaney's email, and the notice of interest. Lauren was already inside the conference room when we entered. She sat beside a tall man in his late 40s with rimless glasses and an expression trained to reveal nothing. Thomas Avery. He stood and offered a polite handshake. "Ms. Price," he said to me, "thank you for coming." Lauren did not stand. "Let's resolve this efficiently," she said. Rebecca took the seat beside me. For the first 10 minutes, the tone was restrained. Avery described the codicil as preventative. Lauren referred to it as responsible planning. They emphasized continuity, stability, the importance of shielding the business from disruption. Rebecca listened without interrupting. Then she opened my binder. "Let's establish a timeline," she said calmly. She placed the original will on the table, signed 5 years ago. Equal co-executors, equal shares. No incapacity language beyond standard court determination. Then, she placed the codicil beside it. August 22nd, she read, "Executed while Ms. Hannah Price's minor child was hospitalized for respiratory complications." Lauren shifted slightly. "The codicil introduces discretionary authority, contingent upon emotional compromise," Rebecca continued. "A term undefined in the document. It's standard language," Avery replied. "It is not," Rebecca said evenly. "And it appears an inquiry was submitted to the company accountant last week citing this clause." All eyes turned briefly toward Lauren. "I asked questions," she said quickly, "because Hannah is clearly overwhelmed." I felt my spine straighten. "Overwhelmed does not equal incapacitated," Rebecca said. Avery folded his hands. "No formal petition has been filed," he said. "We are merely exploring options." Rebecca slid another document across the table. "Then explain the draft operational transfer memo prepared, but not filed," she said. Lauren's face drained of color. "That was preliminary," she said. "In case of emergency." "This is an emergency," I said quietly. "My son is in the ICU." Silence settled across the table. Rebecca continued, voice steady. "My client has performed all fiduciary duties without interruption. Payroll processed. Vendor contracts maintained. There is no documented failure of capacity." Avery's posture changed. "Not dramatically, just enough. Given the dispute," he said carefully, "we may need court clarification." Lauren's composure cracked slightly. "You're turning this into litigation," she said, looking at me. "Mom never wanted that." "Mom never wanted me labeled unstable," I replied. There it was, out loud. Lauren's eyes hardened. "If the business suffers because you refuse to cooperate, the business suffers if trust is broken," Rebecca interrupted. The air in the room felt thinner. This was no longer a private tension. It was documented, witnessed, recorded. Avery cleared his throat. "Until this matter is clarified," he said, "we will suspend any movement on operational authority." Suspend, not withdraw, Not concede, suspend. It wasn't victory. It was resistance meeting resistance. Lauren gathered her papers abruptly. "This isn't over," she said again. "No," Rebecca replied calmly. "It isn't." As we stepped out into the downtown sidewalk, the late winter wind cut through my coat. "Expect escalation," Rebecca said quietly beside me. "They won't like being slowed." I thought, Eli, breathing without assistance, for the first time in days. I had drawn the line, but now the stakes were visible. This was moving toward a courtroom, and Lauren was no longer whispering. By Wednesday, March 12th, the hospital routine had settled into something almost predictable. Eli had been downgraded from critical to serious condition. He was still weak, still tethered to monitors, but he was awake long enough to squeeze my hand. Outside the hospital, however, nothing felt predictable. At 8 that morning, Rebecca forwarded me a formal notice from First Commonwealth Bank, where Price Mechanical held its primary operating account. The subject line read, "Compliance Review Initiated." I stepped into the hallway before opening the attachment. The bank had flagged irregular authorization inquiries related to operational control and short-term liquidity assessments. It referenced internal documentation requests submitted within the last 2 weeks' requests tied to the codicil language. Lauren's inquiries had triggered a compliance review. I read the letter twice. It was not an accusation. It was procedural. The bank would temporarily restrict any structural changes to account authority until documentation was clarified. Restrict, not freeze, not seize. Restrict. Rebecca called minutes later. "This is significant," she said. "Banks don't like ambiguity around fiduciary authority." "Will it hurt the business?" I asked. "It could create temporary delays," she admitted, "but it also prevents unilateral action." Unilateral action. That had been Lauren's leverage. By mid-morning, Mark Delaney emailed both of us, requesting clarification on several intercompany transfers made in September and October. The amounts were not catastrophic, but they were large enough to matter. I stared at the spreadsheet he attached, transfers labeled as operational smoothing. I did not recognize authorizing them. I called Mark directly. "Those were initiated under Lauren's signature authority," he said cautiously. She indicated they were temporary rebalancing measures. "Were they repaid?" I asked. "Partially," he said. "Some remain outstanding." Outstanding. The word felt heavier than the numbers themselves. I ended the call and sat back in the plastic chair beside Eli's bed. The ICU monitor hummed steadily. For the first time, the situation shifted in my mind. This was no longer about emotion. It was about documentation. Lauren had framed me as unstable, but she had left a paper trail. That afternoon, Rebecca and I spoke again. She had already requested a preliminary accounting from Avery and Cole. Now she suggested expanding the scope. If we demonstrate irregular financial movement concurrent with an incapacity narrative, she said the court will scrutinize motive. I thought about the codicil's reference to liquidity review, about the timing in August, about September transfers. "Are you suggesting misuse?" I asked carefully. "I'm suggesting we verify," she replied. "Verify, not accuse." I opened my binder and began adding tabs. August codicil, September transfers, October additional entries, March incapacity inquiry. For months, I had assumed good faith. Now, I was assembling chronology. Late that afternoon, Lauren texted me for the first time since the meeting. "You're destabilizing everything." I looked at Eli, propped slightly, upright breathing without assistance. No, I thought. Something else is destabilizing everything. I did not respond to her text. Instead, I forwarded it to Rebecca and added it to the file. The hospital lights dimmed as evening approached. Nurses shifted quietly between rooms. Inside me, the panic that had accompanied those first whispered words in the ICU was gone. In its place was something steadier. Lauren had tried to frame instability. The system had begun to look at control, and for the first time, I felt the ground shift back beneath my feet. This wasn't finished, but it was no longer one-sided. Tuesday, March 18th, was the day I understood that karma doesn't need a dramatic entrance. It just needs paperwork. Eli had been transferred out of the ICU the day before. He was in a step-down unit now, still on oxygen, still watched closely, but no longer surrounded by the constant alarms and glass doors. When he fell asleep that morning, his fingers still curled around mine. I finally had enough space in my chest to think without panic. At 9:30, Rebecca Sloan called. They responded, she said. Lauren, I asked. Avery and Cole, Rebecca corrected. And it's careful meant they were scared. Rebecca emailed me a copy of their letter. It was written in clean, formal language, the kind that tries to sound neutral while quietly retreating. They stated they were reviewing internal documentation procedures and would temporarily suspend further administrative adjustments, pending court guidance. Suspend again. Still not concede, but it was movement. Then, an hour later, Mark Delaney called. Hannah, he said, and this time his voice didn't have that cautious politeness. It had weight. I finished reconciling those September and October transfers. My stomach tightened. What did you find? I asked. They were booked as operational smoothing, he said. But the destination accounts were not operational accounts. I waited, not breathing. One was a personal account under Lauren's name, he continued. Another was linked to a credit line you were never notified about. The amounts weren't enormous compared to total revenue, but they were repeated, patterned. That was the word that mattered. Rebecca asked for the details immediately. Mark agreed to provide a sworn statement and supporting documents. By noon, First Commonwealth Bank's compliance officer called Rebecca to confirm a formal review was now active. Their tone was professional, but the message was simple. Account authority would remain restricted, and any attempt to alter signers would require court-approved documentation. Lauren could no longer touch the controls. Not because I had yelled, because she had left receipts. At 2 p.m., Rebecca filed an emergency motion in Allegheny County Orphans Court, requesting a temporary injunction on estate transfers and immediate accounting of business funds. She attached Mark's preliminary findings and the bank's compliance notice. That was the highest point of risk so far. Once something is filed, it becomes real in a way family arguments never are. Late that afternoon, I got a voicemail from Lauren. Her voice sounded strained, higher than usual. Hannah, this is getting out of hand, she said. You're going to destroy everything Mom built. Please call me. We can fix this privately. Privately. That word used to work on me. It used to mean keep the peace. Don't embarrass anyone. Let it go. Now, it sounded like a request to go back to the shadows, where she was comfortable. Rebecca advised me not to respond. Instead, we waited. The next morning, the court granted a temporary restraining order on further estate adjustments until an accounting could be completed. It wasn't final justice. It wasn't the end. But it was the system drawing a boundary in ink. Lauren's attorney requested a continuance. Avery and Cole quietly withdrew from representing any further operational changes. Mark Delaney, the man who had filed my mother's taxes for years, was suddenly answering questions under oath. My sister's strategy had depended on speed and silence. Now, everything moved slowly, publicly, documented. That evening, I sat beside Eli's bed in the step-down unit and looked at the thin, white hospital bracelet still in on his wrist. It was creased and worn from days of being touched and checked and scanned. It reminded me that none of this was about winning. It was about not being erased. Karma had clocked in, and it was keeping time. What remains? Friday, April 11th. The courtroom felt smaller than I expected. Eli had been home for 2 weeks by then. He was still thin, still recovering, but strong enough to sit at the kitchen table and argue about homework again. The white hospital bracelet had finally been cut off and thrown away. I kept it in my desk drawer anyway. Rebecca Sloan sat beside me at the long wooden table in Allegheny County Orphans Court. Across from us, Lauren looked composed, but the sharp edges had softened. Thomas Avery was no longer at her side. She had new counsel now, a quiet woman flipping through a stack of financial disclosures. The hearing was not dramatic. It was methodical. Mark Delaney testified first. Under oath, he outlined the September and October transfers, the personal account deposits, the undisclosed credit line. He explained how the codicil's language regarding operational disruption coincided with the movement of funds. He did not speculate. He read numbers. Rebecca then presented the timeline I had built in, that ICU chair, August codicil, September transfers, March incapacity, inquiry, clean, sequential, documented. Lauren's attorney argued intent. She described the transfers as temporary reallocations. She described the codicil as protective planning. She framed everything as misunderstanding between sisters navigating grief and stress. But intent without transparency sounds different in a courtroom. The judge, a gray-haired woman who had likely seen every variation of family drama imaginable, asked one question that shifted the air. Why was Ms. Hannah Price not notified in writing of these transfers at the time they occurred? There was no clean answer. By mid-afternoon, the ruling was issued. The court ordered a full forensic accounting of Price Mechanical at Lauren's expense. The temporary restraining order was extended. Lauren was formally removed from any unilateral authority over estate or business funds, pending review. The codicil language, referencing discretionary incapacity, was deemed ambiguous and unenforceable without independent medical certification. In plain terms, the narrative collapsed. Lauren did not look at me when the order was read. Outside the courthouse, she finally spoke. "I was trying to protect the company," she said quietly. "Protection requires trust," I replied. She nodded once, but it was an agreement. It was resignation. The forensic audit would take months. The financial penalties would be calculated later. The damage to our relationship was harder to quantify, but the system had done what it was designed to do. It had placed weight where weight belonged. That evening, I sat at our kitchen table while Eli worked through math problems. The house felt ordinary again. The hum of the refrigerator, the ticking of the wall clock, no ventilators, no whispered accusations. Price Mechanical would survive. I would remain co-executor. The estate would proceed under court supervision until finalized. Justice, I learned, rarely feels triumphant. It feels steady. It feels like breathing without someone watching to see if you fail. I opened my desk drawer and looked at the thin, white hospital bracelet. For weeks, it had symbolized vulnerability. Now, it felt like evidence of endurance. Lauren and I would likely never return to what we were. But I was no longer fighting to prove I was capable. I was simply living it. If you've ever faced betrayal, wrapped in family language, I'd love to hear how you navigated it. Share your thoughts below. And if this story resonated, stay with us for the next one. Sometimes, justice is quieter than revenge, but it lasts longer.